morning, everyone. Today is July 15th, 2021, and welcome to the New Possibilities Hour, part of the Will Work for Food project, founded by Natalie Armstrong-Motin in the spring of 2020. Each week, Jean Lawler and I are delighted to host these webinars for negotiators, mediators, and lawyers all across the world. We don't charge for these great webinars. Rather, we ask people to contribute to a food bank of their choice if they like what they see. And our audiences have been so generous so far, and I know will continue to be generous into the future. Jean, it's always one of our favorite parts of the webinar each week when we ask each other to report the running total of just how generous our audiences have been with food banks. So please, the drum roll, the good news, please.
Da, 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 da. Well, we're almost to $145,000, 144,785. So I think that we will hit that $150,000 mark this week.
I'm confident we will, because I know we're going to have a great conversation with Shari today. We have well over 100 people here, and we appreciate it very much. Shari's going to tell us a little bit about the food bank that is important to her and her community just when she begins her presentation in just a moment. So let's get to it. Shari Belitz, Esquire, is a nationally recognized litigation consultant, keynote speaker, author, Chief Executive Officer of Shari Belitz Communications, LLC, and the founder of EnPSYCHLAWpedia. Shari Belitz Communications, LLC is a litigation consulting company which teaches lawyers how to use social psychology to achieve favorable litigation outcomes. Shari is an attorney with over 20 years of experience in the legal profession. Before her litigation consulting career, she was an accomplished insurance coverage lawyer at a large law firm and litigation manager in-house at an insurance company where she handled mass tort lawsuits for Fortune 500 insured clients. Shari has been a student of forensic psychology, including advanced jury science and research at the graduate level. And what I asked Shari to do is to have some fun with the presentation today. We've got a very sophisticated audience that knows the basics of social psychology and behavioral economics, and we've all read books by Daniel Kahneman and Dan Ariely and people like that. So I said, Shari, take us to the next level. Really, teach us stuff that otherwise we would not know, insights we otherwise would not have. Shari, we're just delighted to have you here today. We're looking forward to a spectacular hour. Please tell us a little bit about the food bank to which you'd like people to contribute if they're in a position to do so. And then on with the show. The floor is yours.
Absolutely. Thank you so much, Jeff, for having me. Thanks, Jean. Thanks, Natalie. I have been a New Yorker for 25 years, so welcome, LA. It's great to zoom into LA. And I am raising money for the New York Food Pantry. So I am very excited about that charity. It's an excellent charity right in my backyard. So thanks so much for that, Jeff. You want me to take it away, or you have a couple more words?
No, go. I have your PowerPoint here, Shari. And
okay, bonus.
And if you would like, I will start screen sharing, and just let me know when to advance the screens.
Okay, amazing. I think we have to go into slide share.
Okay.
I believe we have to go into slide share.
And
but I'll just
why don't you start, and I will try to figure out how to get us into slide share.
Why am I getting the sound and I can't even get the
okay, couple technical difficulties this morning, but no big deal. We are going to just go with it, and that is a great lesson for trial lawyers, just to go with it. Never have any notes or PowerPoint that you are so dependent on, because I was going to have to go cold up until a few minutes ago. So Anyway, welcome Los Angeles. I'm so grateful to be here. I love presenting in Los Angeles. I get to sleep a little late, so I thank you for getting up a little early. I know we have 750 people here, last count, so that's amazing. I feel like a Kardashian. We're gonna raise a ton of money for the New York Food Pantry. So let me give you a little bit of an introduction, even though Jeff gave me a pretty robust introduction. Who am I? So for those of you who don't know me, and I know that sounds kind of presumptuous, but I do know a bunch of you from LinkedIn, so hi to all my LinkedIn friends. And those of you who don't know me, I'm Shari Belitz. I'm a trial consultant. I started my career as an insurance coverage attorney at a firm in downtown Manhattan where I worked in the 1990s, shepherdizing on the books and all, you know, just kind of very 1990s, right before all of the dot-com boom. So it was really quite a different world as far as everything, but it was kind of before we got really tech savvy, except for one guy in my class who started an e-discovery company. He was a little savvy earlier than most, but I quickly went in-house to an insurance company, spent a majority of my career at AIG. It was a wonderful time and learned a lot about litigation. And then at night, I took a leap of faith and pursued a dream that I always had and went back to school at night, to graduate school, to study forensic psychology with a concentration in jury research and in jury science. So it was fascinating. Aside from the jury classes, I got to study psychopaths for a full semester. I got to study the Rorschach exam. I had an FBI profiler in one of my classes, a hostage negotiator in another class. It was a really fascinating time in my life. However, I really always had an eye towards trial consulting and wanted to do trial consulting in larger cases like the ones that I was handling at the time at AIG. So fast forward many years later, my kids are a bit older and I got into trial consulting and started my company and then started an educational company, EnPSYCHLAWpedia. I apply psych to the law. It's a video course, and it really is just my passion to teach lawyers, to teach litigators how to apply psychological concepts to various litigation concepts. So it's really the intersection of my passions of psychology and the law. Okay, so let's start really simple. I know we don't have this PowerPoint completely queued up. Jeff, I think if you hit slideshow or presenter mode, you might be able to get there, but that's okay. I'll just talk you through it and you can kind of see some of the slides. Or Jeff, you can actually hit the next slide and we can see it that way. Yep, we can do it like this. This is fine. And my PowerPoint is available to anyone who contacts me. I have contact information on slide 1. So we'll go back to that. Okay, so let's start really simple. Jeff has told me this is a sophisticated audience. You've read Dan Kahneman, you've read Dan Ariely, you know about behavioral economics, but let's just start with some foundations that we're going to keep going back to before we take a deeper dive. So, juror decision-making. Let's talk about human decision-making and the brain. And if you've read Kahneman, a lot of this is really right from Thinking Fast and Slow, because I think it's a very good simplistic explanation. So, we have a part of our brain, and it's really a system of our brain, the limbic system, amygdala, cerebellum, all that boring stuff, that is our fast thinking system. That is unstructured reasoning, emotionally influenced reasoning. It uses stereotypes, it uses heuristics, it uses mental shortcuts to make decisions. And that's where we're going to be taking a deep dive when we talk about cognitive biases, and then we're going to apply it to some litigation concepts. On the other hand, we have another system, a slower thinking system, that well-developed cerebral cortex. That is your area of higher reasoning. That is your thinking slow, thinking logically, thinking with reason. There is a misconception that people think one way or the other, and it's true, you may skew one way or the other. For example, engineers, accountants, people of that ilk often are very high in the deliberative process, possibly lower in intuitive, and you have maybe more artistic people, more creative people thinking more intuitively, but it's really circumstantial and it depends on the situation, and our minds are capable of both, and that's what we're going to talk about. We're really going to get into that intuitive thinking fast when we talk about the cognitive bias. So my next slide, Jeff, is the cognitive bias. Nice little picture of the brain. What's the cognitive bias? The cognitive bias, I look at it as like, it's like this little gossipy system that's kind of like running around the amygdala, the limbic system, the cerebellum, and it's making snap decisions. It's telling the brain to make snap decisions. It's saying, be lazy, take the easy way, take the mental shortcut. You don't have time. You don't have time to deliberate. So that is the cognitive bias. It emanates, it's very anthropological in nature. It emanates from our chaotic world and really trying to organize that world in categories, which is why we use stereotypes, why we use mental shortcuts. And the cognitive bias is something, it happens in life, it happens all of the time in life, it happens across professions. I'm going to just talk about law, which is where I see it, but it happens very frequently in medicine. It happens in politics, it happens in finance, it happens when we're making a decision whether, and I know this is kind of New York based, whether I'm going to take the cab or take a subway. I'm making a snap decision based on often irrational information, as Dan Ariely would say. Okay, so let's get to our first cognitive bias, which is the next slide. It's the availability bias. Availability bias, one of my favorites, that's my bias, and that is being dependent on information which comes to mind quickly and which we see frequently. So a common question when we talk about availability bias is, what happens more frequently? Do people die in fires or do people die from drowning? And most people are going to give a snap decision, people die in fires. But that is actually not the case. Statistically, it's drownings. We hear about fires more. That is really what we hear about a lot, and what we hear about frequently. So that's the availability bias. Now I'm going to give you an example, and I'm going to apply it to litigation. I know we have, so usually I speak with defense attorneys and insurance professionals. That's where I do a lot of my work. But I'm kind of glad there's a lot of plaintiffs' attorneys here today and attorneys in various areas, because it's going to make me lose my confirmation bias, which we'll talk about later, and really give you a more neutral perspective than I do when I'm talking to my client base, which is defense, basically. Okay, so let's talk about an example which really needs to be updated, and I think I'm going to probably use Surfside as my update, and I'll just throw in a couple words about that. But here's my example, and it's pre-COVID, so it is about outdated. 2019, New York City. Obviously, it seems like a million years ago, pre-COVID, we had one news story that was just captivating New Yorkers, and that was just monopolizing the news. And that was a young man, about 30 years old, was in his apartment building, residential apartment building, Midtown Manhattan, was in an elevator full of people, and the elevator started bouncing. So he stepped out trying to get to the lobby. It was bouncing by the lobby. And then it started really shaking a lot. He stepped into the threshold and he was crushed, pinned against the wall, and killed in this scenario. And there was an elevator full of people, lobby full of people, really catastrophic, terrible. So what did we hear in the news for the next, it was probably a couple of weeks. This is all we heard. This is all that was on the New York Post. This is all that was on New York One. This was the biggest news story, and New Yorkers were terrified. There were people, they were being interviewed. They would not take their elevators. There was a pregnant woman. She had walked 20 floors to get to her apartment. People were so afraid of their elevators. However, statistically, New York City 2019, what was your real threat? Your real threat was walking out of your apartment, getting hit by a car, a cab, an Uber, a bike, or a scooter because you're distracted on your phone. That statistically was your real threat, but you didn't hear people saying, you know what, I'm not gonna leave my apartment. I'm afraid I'm gonna get hit by a cab today. You heard them being so fearful of these elevators, and that's the availability bias because that was playing on the news. And we see this with big news stories. So Surfside, for example, now you have, and not just in Florida, my mom has a small condo at a beach. And what was the first thing she did? Went to the board and started asking about inspection and records and all sorts of things. So again, availability bias. Okay, let's talk litigation. How are we going to apply the availability bias to litigation? Well, if we are plaintiff's counsel and we have something like this elevator case, we have something like Surfside case, we have something that is in our faces, and pretrial publicity is a whole other topic, we are going to exploit that availability bias. We are going to perhaps reptile that. Those of you who've listened to me have heard about the reptile theory. I'm sure everyone is somewhat familiar with it, but we are going to tell that jury that this could have been you. This was a danger. Defendant's conduct or lack thereof was a danger to the community. And there but for the grace of God. So that is the argument. A plaintiff is going to want to exploit the availability bias. However, I am usually working for the defense side. I'm usually talking to defense attorneys, and I am telling them they need to mitigate the availability bias. They do not need to exploit it. It's going to be exploited by the plaintiff's side. They need to mitigate it. How do they mitigate it? They get back to that deliberative reasoning we looked at in the first slide. They want to bring the jurors back to that cerebral cortex. They probably want to make sure they have that when they're doing their voir dire. So they are going to want to use statistics. They're going to want to use data. They're going to want to put that data in graphics, and they are going to make an isolated incident argument and take things away from that reptilian school of thought and take things away from the availability bias. Okay, so moving on to the next bias. This is going to be very near and dear. That's the next slide, Jeff, is the anchoring bias. Anchoring bias, this is probably, I know there's some mediators out here, so you've probably heard of a lot in terms of negotiation, in terms of numbers, in terms of monetary amounts, which is absolutely how most lawyers have heard of it. So the anchoring bias is a cognitive bias where an individual depends too heavily on an initial piece of information when they are making decisions. And then once this anchor is set, all future negotiations are going to be filtered through this lens. So for example, and there have been research studies done, you take an identical case and you have a demand for $20 million in one case, and in the other case you have a demand for $10 million. And studies have shown the case where the demand is $20 million is going to settle higher because that anchor was set higher, the bar was set higher. As a friend of mine who's a defense attorney, Bob Tyson, likes to say, and I think it's so brilliant, is how do you get a large verdict? You ask for it. And I see this so many times, it's really quite scary from the defense side because I'm observing mock trials, I'm a fly on the wall watching deliberations all the time. And what you see is mock jurors looking at that demand and saying, wow, $20 million. Well, there has to be a reason for that. I mean, I'm sure there's a reason, or otherwise they wouldn't have asked for that. And they're working backwards. I recently saw this in 3 separate mock trials. So really that anchor is so important when we're talking about monetary negotiations. It's so powerful. I'm going to show you how to exploit it or how to refute it. But first I want to show you an experiment. And those of you who are familiar with Kahneman may recognize this experiment. I just think it really illustrates things in such a powerful way. I call it the loaded dice experiment. It wasn't done by Kahneman, but he talks about it in one of his books, and he talks about it in his many studies that he's done on anchoring and adjustment. He really is, him and Eamon Tversky are kind of really the thought leaders as far as anchoring and adjustment. So, you know, I nerded out on their articles a very long time ago, and much before Thinking Fast and Slow. So I'm familiar with his work, and I think this study is fascinating. So this study was an experiment that was conducted where a sample of judges were asked to impose a prison sentence for a woman who was accused of shoplifting. I know that sounds really harsh. The study was not done in the United States. It was done somewhere where there are maybe harsher punishments for shoplifting. But anyway, before this fact pattern was read to the judges, a set of loaded dice was thrown before each judge. Now, loaded dice are just dice that are predetermined to have a certain number. And on each set of dice, they were either predetermined to come up with a 3 or a 9. So a 3 or a 9 was rolled before each judge, the judges being totally oblivious to this process. Then they were read this fact pattern about the woman who was caught shoplifting and asked to impose a sentence. Now, what were the results? The results were the judges who rolled that 9, that predetermined 9, proposed a sentence of 8 months in prison on average. And what about the judges who rolled that predetermined 3? They proposed a sentence of 5 months on average. Now, dice are called an unrelated anchor with respect to prison sentences. I mean, maybe if we were talking about craps or something like that, they'd be a related anchor. But as far as prison sentences, they were an unrelated anchor. So it's really scary how an unrelated anchor can influence something that is just completely not related to it all at all. Imagine if they were reading about prison sentences, that would be a related anchor and perhaps even more influential. So moving on to the next slide, anchoring themes in litigation. Again, when we think about anchoring, a lot of times we're thinking about numbers, we're thinking about negotiation, but themes can be anchored, words can be anchored. Thoughts can be anchored if we express them. And I talk a lot about this when I'm working with clients, because this is important to come up with a compelling theme, and we'll talk about this later. So let me give you an example here. Let's say plaintiff has a theme. This is a case about profits over people. I'm giving you a very broad theme. Generally, plaintiff is going to have a more narrow theme and defense is going to have a more universally broad theme. But just for the sake of this presentation, plaintiff comes up with, this is a case about profits over people. Should defense come up with a theme that negates it? This isn't a case about profits over people. Absolutely not, because if they do that, if they negate that actual theme, what they are doing is they are implicitly accepting it in the minds of the jurors. That is implicitly giving it credence, giving it credibility. They need to come up with their own compelling, persuasive theme. So for example, they might want to say, this is a case about personal responsibility. This is a case about making good choices. So let me give you an example as it pertains to mediation. That's more of like a straight litigation courtroom example. So the next slide, when we're refuting an anchor, even if we're refuting a number, it's very important not to respond right away and to really slow down that thinking process and to not implicitly accept. Because let's just say the plaintiff, who's always going to set the anchor, says $20 million demand, and then you counter with $2 offer. What you've just done is you've implicitly accepted, in the minds of the mediator, in the minds of the parties, in the minds of everyone who is in that negotiation, you have just created a midpoint problem by implicitly accepting their anchor. By giving your offer right back, you've implicitly given it credibility, and you've created a range, and you're going to have a midpoint problem. And as Kahneman and Tversky would say, you're going to adjust to that midpoint, because that's how the anchoring bias works. So what's the solution? Setting your own data-based anchor, which will mitigate your midpoint problem. I had a case, it was a construction defect case. My client had a very generous offer to an absolutely catastrophic demand. However, the demand was based, there was really an impasse in negotiations. The demand was based on past costs and future costs, whereas the defense was looking at the case differently, and it was just based on past costs. It was a large offer, but it was not taking into account futures. And in a situation like that, you can kind of stop those anchors, just kind of put a stop to that and say, I think we're viewing this case very differently, and start talking about that impasse. And that's a way to really refute the anchor, because if you're looking at the case differently, you're not implicitly accepting the anchor. Okay, so 11:30 here, we're still doing well on time. Moving on to confirmation bias. Confirmation bias, another one of my favorite biases to talk about, because I do believe it is the most detrimental to litigation, and I believe it is the most common in litigation. And I like to say, don't fall in love with your case. And I tell defense attorneys, don't fall in love with your defenses. I say, I'd rather you fall in love with co-counsel. Just don't fall in love with your case or your defenses. It can be a lot more expensive. Though I can see how falling in love with co-counsel might be a little expensive in its own way. But I really joke about that when I talk about confirmation bias. So confirmation bias is seeking information which confirm our pre-existing beliefs and ignoring, disregarding, dismissing strong arguments on the other side as far as litigation. However, confirmation bias is something we don't just have in litigation, we have it in life. It's very common in politics, it's common in the news that we consume. We are going to usually consume news that confirms our own existing beliefs. As a trial consultant, I actually try to read a lot of plaintiffs' publications to refute my confirmation bias and to really help me see things in a neutral way. I also like to read a lot of newspapers. I still read like old-fashioned newspapers. So every morning I'll read the Times, the Journal, and the New York Post, and they give me such different perspectives on really what is the same set of facts. So it's very helpful as far as bias. We can even find confirmation bias in our social media feeds. For example, on LinkedIn, I did a survey the other day about really different types of music. Like, do you want to hear something from the 60s, the 70s, the 80s, the 90s was the gist. And most people voted for the 80s. And I said, oh, okay, good. That's my favorite. Well, should that be a surprise? Probably not. I grew up in the 80s. I'm quintessential Gen X, and probably most of my contacts are as well, and most of the people I engage with. So it's actually not at all surprising. That's confirmation bias on all of our curated social media feeds. So let me talk about it in litigation. Happens all the time. Again, defense side, I get a lot of cases where there are violent third-party acts on insured premises because these cases are very hard to evaluate. Liability is often defensible, but damages are quite shocking, so we put them to mock trial. Had a case, horrible case, rape case. Woman was kidnapped, raped, tortured for 48 hours. I was speaking with defense counsel on the intake call, and all defense counsel was talking about was how great the lighting and the security was. And I said, don't fall in love with your defenses, and just started playing devil's advocate and asked a bunch of questions about the plaintiff and the plaintiff's damages. So very important. How do we defeat confirmation bias? Again, this is information, not infomercial, but really the gold standard to defeat confirmation bias in litigation is to run a mock trial. I'm going to give you other ways to do it where, you know, I don't want to be sitting here selling you my services. That's not what I'm here to do. So I'm going to give you other options if that's not an option. But a mock trial, every mock trial I've done where we have our defense attorneys, one plays defense and one plays plaintiff, and the one who plays plaintiff always tells me, I have learned so much about my case by arguing the other side, and it's really helped me see their point of view, and it's helped me see where my weaknesses are in my case. So what I'm going to propose, and I know I worked at an insurance company, there's not always the budget, there's not always the time, sometimes there's politics involved, you can't always do the gold standard, but my mantra is something is better than nothing. So argue the other side of your case. You can absolutely argue the other side of your case, whether it's to yourself, whether it's to a colleague, whether it's to someone working on the case, and everyone's going to have their own confirmation bias. This isn't going to give you neutral sample sizes or a pristine result, but it will help you see the strengths of the other side and perhaps your own weaknesses. If you have a firm that is large enough and has other practice groups, I'm going to say argue to another practice group. You have a benzene case, go argue that in front of your real estate group where they don't know what a benzene case is, unless it's like an Aaron Brockovich scenario, which your real estate department would know what a benzene case is. But you get the idea. Get another perspective. Again, you're going to have biases. Again, you're going to be arguing in front of a bunch of lawyers. But if you can't do the mock, and it's totally understandable, it's not right for every case, argue the other side, make a weakness strength list, do things that are going to rid you of your confirmation bias. When I read a new case, I read things in a certain order so I don't get biased. I don't read the mediation statements. I don't read reports from my defense counsel. I will read pleadings first. I will read things so I go in with a less biased mind because I'm aware I have my own biases. Okay, still
Shari,
good.
let me ask a question. Oftentimes
Sure.
in mediations, we're sitting there and we listen to people and we go, oh no, they're too close to their case. They've fallen in love with their own case. We got to do something to help them. But we know that we can't just say you're wrong. We have to have more subtle and nuanced approaches. What are some suggestions as to how to approach somebody, how to start into the conversation where we're concerned that somebody has just fallen in love with their own case?
Well, One suggestion, and this is something from a LinkedIn post that I saw yesterday, and I started engaging with it, and it was kind of the same gist. How do we really get people grounded in reality and to lose their confirmation bias? One thing, and again, I don't hold myself out as a mediation expert, but as far as psychology, I would try to find out what are their underlying motivations. What are, if you're talking about, and again, I'm going to just give you kind of straight plaintiff defense personal injury type of case. If you're talking to plaintiff, maybe there's something, maybe they want their day in court. Maybe they want to send a message. Maybe there are some other underpinnings, and it's not all about the money. It's something more about the process. And they don't realize, a lot of plaintiffs, of course, will not realize just how terrible the litigation process is, like how expensive, how draining, like in this case that I was talking about with this rape victim in a civil case where the criminal case was already decided. Like, this is terrible to have to go through that again. So to understand, really just kind of walking them through the process while delicately pointing out, like, say, you know, like, I think, Mr. Jones, you have, you know, I understand where you're coming from and you want to send a message, and this is terrible what happened to you. However, to prove that, you're going to need X, Y, and Z, and it looks like you only have X. And then it's going to go through a motion process, and then it's going to go through this, and it's going to take this long, and whatever it is. So that's what I would say with respect to plaintiffs. Defense is a little more tricky, I think, because a lot of, you know, if you're dealing with insurance carrier and tripartite relationship, you could have some politics right there. Maybe you have an insured who's never been sued. Maybe you have an insured who has 100 lawsuits pending against them, and they're quite familiar with the process. There may be other considerations. Will they become a target defendant if they don't fight? Like, find out what the other considerations are. Like, I like to look at the root and then kind of explain to them delicately what you see the weaknesses of their case to be, and, you know, walk them through the process. And again, if this is an insured defendant who has a zillion cases pending, and this is just one more, I mean, that's going to be someone who's sophisticated about the process. But again, I think that's a good strategy with respect to plaintiffs. And I think that a good strategy with respect to defendants is, you know what, you're not just, you're getting closure, you are getting a reputational, this is saving your reputation. What if this is something like that elevator case I talked about? Do they want that splashed all over the papers for weeks and weeks? I mean, there's a lot of benefits to mediation, so you can kind of tout the benefits while pointing out the weaknesses, and, you know, certainly the finality, the closure, and things like that is much more appetizing than the appeal process. So that's my answer to that. Before we move on to, we're cutting it really close. Do you want me to
move on to the next slide?
Okay, yeah. I am going to actually, okay, let me just like race through this, and I'm here as long as anyone wants for questions. So if that's an issue, I can stay, but let me just race through this one before we get to storytelling and themes. Social desirability bias. Everybody who is a trial consultant asks me about voir dire. People think this is all that I do, and it is one of the parts of the job that I love doing. So I, you know, wouldn't be a good trial consultant if I didn't talk about the social desirability bias. So social desirability bias, this is your biggest obstacle between an attorney asking questions and an honest answer in voir dire. People want to present themselves in the best light possible. They want to, if they're in front of especially a peer group of strangers, social desirability bias is heightened. So in order to really, you want to mitigate this, both sides want to mitigate this, because you want to pull out honest answers in voir dire, and you need to pull out those honest answers in voir dire because you need to elicit their biases about your case, and then you want to send them home sweet home. You don't want to do mini openings and start to convince people about your case. If you have biased jurors, their minds are made up. Thank them and send them packing. But to elicit their biases, you're going to have to get around social desirability bias. So, couple of things. One, normalize that it is acceptable, it's okay, and it is quite normal to have bias. Give an example of your own bias. I like to give a crazy example. Just say, you know, I'm a New York Yankees fan. I would be a terrible juror on any case that had to do with the New York Yankees. In fact, I'd probably be a terrible juror on a Boston Red Sox case. Any other case I'd be great on, and it's okay that I'm biased. Use body language, talk about the case. Does anyone think that corporations put profits over people sometimes? And get them to raise their hands, start questioning them, and set up your cause challenges and earn them. I see this a lot, attorneys asking about ability to be fair. Okay, that's a question in the absolute. No questions in the absolute should be asked. They are really putting jurors on the spot. Social desirability bias is going to rise. Instead, and also no one likes their ability to be questioned. So instead, use a hedge word, make it softer, use a gradation, something like, might you have some difficulty? Mr. Smith, I see that your wife is a doctor. Might you have some difficulty thinking that doctors may make catastrophic mistakes when they're tired? Could you easily? So things like that make things a little bit easier to kind of circumvent that social desirability bias. And now we move on to storytelling and rhetoric. Okay. So storytelling, information presented in the form of a story is more likely to be comprehended. It's more likely to be recalled. And when we only have parts of a story, we tend to fill in the parts with our own biases, with our own cognitive biases. That's what we default to, that lazy line of thinking, that intuitive thinking from the first slide. Okay, so confession, and I can't see anyone here. I can't even see myself because just of my setup, but honor system here. Who loves Better Call Saul? That is my favorite TV show. I love good television. I love Better Call Saul. I'll even say this, I think it's a better show than Breaking Bad was. I love it that much. So what's great about Better Call Saul, aside from the fact that Bob Odenkirk is a genius? What's great about Better Call Saul is, for those of you who don't know, it is a prequel to Breaking Bad, my other favorite show, my second favorite show. And a prequel is really cool, and it has a lot about storytelling, a lot to teach us about storytelling, because it fills in the blanks from that first show. And it kind of, even blanks that you didn't even know you had, you kind of just say, oh, that's why he has the coffee mug. That's where he got it from. Oh, now I know why he has a bad back. That all of a sudden makes sense. So prequels are really cool. My business partner, I'm really disappointed. She doesn't like Better Call Saul. She does not like Breaking Bad, but she loves Star Wars. And she actually we've had these discussions, and she tells me that she feels this way about, the Star Wars prequels. Okay, so moving on. What do you need to tell a persuasive story? Okay, what you need is two things. You need coverage and you need coherence. Coverage is the amount of evidence that's accounted for in a story. Coherence is consistency. Does it make sense? Is it plausible? So seems pretty simple, right? I told you guys a story at the beginning. I told you a little bit about my career trajectory, and I can add to it. I can give you kind of my undergrad and, you know, why I went the way that I did, and I can add more coverage, and it'll give it more coherence once I add the coverage. However, I am not taking into account two things which you have to contend with in litigation. One, the rules of evidence, but again, a good thing about the rules of evidence is a good storyteller can plan around the rules of evidence. However, what it is very difficult to plan around is your competing storyteller. You are going to have holes poked in that story. I may have told you a completely reasonable story about my career. You may think nothing of it and you may believe it, but that competing storyteller is going to tell another story through cross-examination, through their witness. So that is the challenge in litigation. So let's move on. This is kind of my favorite part of storytelling. I think it's so interesting from a psychological point of view is morals. Morals. Why is it important to talk about morals when we talk about stories? It is because jurors need to make moral decisions about who should win cases and how much damages should be awarded. And attorneys can tell a more persuasive story when they understand the moral judgments that jurors make. So let's talk a little about something called the moral foundation theory. The moral foundation theory is in contrast to actually what I learned in undergraduate psychology, which was that morals were a cognitive process. They were a cognitive developmental process. A 4-year-old did not have the same morals as a 14-year-old, did not have the same morals as a 24-year-old. As your brain developed, as you grew, your morals improved, your morals developed. I shouldn't say improved because they don't improve with everyone necessarily. And that's where Jonathan Haidt came in. He's a psychologist. He's at NYU still, relatively young. And he said, no. Morals are not cognitive. Morals are absolutely not developmental. Morals are something that are emotionally based. They're back to that intuitive thinking. They're actually very anthropological in nature, and they evolve from our innate sense of suffering, our ancestors of fairness, of cheating, of lying, and they're really quite inborn. And if you go back to crim law, kind of first year crim law, malum and se, malum prohibitum. Malum and se, we're supposed to all know this. It is inborn that it is wrong to kill someone. So that's sort of a very interesting take on morals. I think it's pretty harsh. I really believe in a combination of the two. But for litigation's sake, let's talk about Jonathan Haidt and moral conflicts, which is the next slide. Jeff, I know we're getting close to the 12 o'clock hour here. So moral conflicts. There are moral conflicts that Jonathan Haidt proposed. There are 5 main moral conflicts, and these are often underpinnings in cases. So the 5 moral conflicts, I have these here. Don't worry about writing them down. I'll give anyone my PowerPoint who wants a copy. Care versus harm. I talk about this one a lot because I talk in terms of personal injury cases. Care versus harm. That is baked into the definition of negligence. A duty was owed and a standard of care was breached. We see fairness versus cheating, loyalty versus betrayal. We see this in a lot of contexts: family law, employment law, contract, intellectual property, then a couple of others. Again, I'll give you the PowerPoint. So moving on, I'm just going to really hit one more topic here because we are getting close and I want to answer some questions. Rhetoric. Next slide, rhetoric. Plato said, rhetoric is the art of winning the soul by discourse. And then next slide, Aristotle kind of refined that definition. We've all probably heard about this. I look at Aristotle. He's like the millennial who made everything better. Plato was like Gen X, who just kind of put the idea out there, which would make Socrates a boomer. But anyway, that's my own crazy take on it. But Aristotle said the three most important ingredients of a well-crafted argument: ethos, pathos, logos, credibility, emotion, logic. There was a great article in Law 360 today about this I read early this morning. Going to give you some samples, then I'm going to turn things over to questions. I'm going to just have to skip the last part because we're running a little tight. Okay, some examples of rhetoric, and if you want to follow me on LinkedIn, I did a whole series on rhetoric and talked about a bunch of different rhetorical devices. Repetition, that's a huge one. Repetition of words. Example, on direct examination. How do your injuries make you feel about your life, Ms. Doe? They make me feel helpless, helpless, helpless. If you read my post from the other day, I was talking about the opioid litigation. Their expert, the addiction expert for plaintiffs, did something really great, which was rhetorical and which dealt with repetition. Is she went through a training manual and everything she said was false. Her attorney took a red pen and wrote false. The jury is going to remember that. This morning, as I was reading one of my papers, I came up with something about Britney Spears. I just highlighted it. Let me read it for you. I didn't have a chance to really commit it to memory yet. Britney has been abused by the media. She's been abused by her grifter father, and she's been abused by the American justice system. Similar to my example here, where we start kind of narrow, we get broad. This is a case about deception, deception in marketing, deception to the consumer, deception to the American people. I had the opioid litigation in my mind. We have alliteration, which is the same letter used repeated times. This clumsiness, carelessness, clodishness is what caused the catastrophic, cataclysmic calamity. And if you're defense and you want to flip the script, and that was plaintiff's contributory negligence. Halting speech or pauses, her innocence, her trust will never be restored. So these are all ways to have the jury remember what you're saying, show the importance. I'm not going to hit my last slides. Instead, I'm happy to stick around as long as you have questions. I can't see the chat bar, but you can, maybe someone can just relay.
Yeah, Shari, this was just terrific. You covered so much territory so efficiently and in great depth, added a lot to people's knowledge base. Thank you so much. Jean, can you take a look in the chat, please? And if there are any questions for Shari, let us know.
Yes, I have been looking at it, and there really haven't been, although there was something early on about the dice. If anybody has questions, go ahead and put them in here, please. Just a lot of thank yous for Shari. But on the dice, were the prison sentences in the loaded dice scenario average or median was one question, if that matters.
That I could not tell you. I don't remember. It's been actually a long time since I've looked at that study, but I'm happy to look it up and let you know. I've actually just copied my notes. I want to put it in the chat bar if I can. I'm sort of like playing around on Zoom right now. I can't really find anyone, but anyway.
We do have more questions popping up, so that's great.
Oh, okay. Ask away. I literally can't see anyone, but I'll ask the questions, and maybe someone can be kind enough to circulate my email or my, find me on LinkedIn. I'll DM you if you send me a DM.
Well, Shari, let me ask you, with terms of anchoring and the dice and things like that, are there ways that can be used by a mediator or negotiator that are both ethical and effective to try to get people to see options they maybe haven't considered before, or to help make deals?
I mean, absolutely, because you have to look at it from a mediation perspective. And I don't often look at things from a mediation perspective, but you would look at plaintiff is setting an anchor, if we're just talking about a straightforward personal injury case, but even in, you know, other contexts, whoever is bringing the suit is setting the anchor. And really, it's important, I think, for the mediator, and mediators have told me, who have had the litigants do mock trials before where they're getting evaluations, it's very helpful to have that data, to come in with a data-backed demand. So if they're coming in with a $20 million demand, ask them for the data, ask them to walk you through that life care plan, or ask them to walk you through the damages, ask them to walk you through, to really just kind of pin down, is this like a $20 million demand in a vacuum? Because we're getting a lot of $20 million demands in Cook County or Bronx County, or, you know, wherever, or is this a $20 million demand, and kind of show me your data. So I would say that's one way for a mediator to really mitigate and anchor. How can a mediator leverage an anchor? A mediator can then really go to defense and say really kind of the same thing. Like, I need a data-backed offer. Like, that's nice that you want to offer like $200 to this $20 million demand, but you're actually implicitly accepting it. Show me what your data says. Oh, your data says $250,000. Well, can you explain it? Can you explain the life care plan? Can you explain how you get that number? So that's what I'd say. Show me the data, like Jerry Maguire.
Here are a couple of very interesting questions, actually. Here's an example. Plaintiff is demanding $2 million at mediation, and you've said not to offer $2 or, you know, the small amount because it impliedly accepts their anchor. The question is, what should we do? Refuse to counter completely? You know, what would be your advice there?
So my advice there is to ask about their anchor, ask about that $20 million demand, say things like, I think we're like in that construction defect example I gave, I think we're seeing this case in a very different way. Can you explain to me how you're looking at this case, hear what they have to say, really hear what they have to say, and get the data behind what they're saying, and then offer your own, like, this is kind of back to this thinking slow, thinking deliberatively, then put down, you know, stop that anchor in its tracks. I think we're looking at this case very differently. This is a case about past costs. These are what we see as the past costs. And, you know, here you go. We see the past costs are $400,000, and this is why. You know, we're here to compromise, we're here to talk, we're here to get some closure, we're here to save defense costs, but this is what we see. And then you're not implicitly accepting it. You're not just throwing back a number to counter a number.
That sounds great, and that answered several questions that were phrased differently. If I might just ask you one more, and then we're at the 9 o'clock hour or the 12 o'clock hour, or wherever in the world you are at the top of the hour. Can you counter biases by making them transparent to the people being manipulated? You know, like, don't fall for the anchoring bias?
Great question. You can. And as we were talking about the availability bias, where plaintiff is saying, this could have been you, this elevator company, this management company put the community in danger. It's up to you. Take out your checkbook and send a message. This could have been you. It could have been your neighbor. It could have been your parents. It could have been anyone. It happened to be this guy, but you need to send a message. Your defense, get them back to the cerebral cortex and show them the data and make an isolated incident argument. Show that statistically, tell them this is, you might not want to say bias because people have a biased idea about what a bias is, but you might want to say, you know what? We've heard about this case. We've heard about it in the news. It's awful. We've seen it, like, terrible tragedy, what's happened. Take responsibility for what you can take responsibility for, but then bring it back to it's an isolated incident and show why it's an isolated incident. Use statistics, get them thinking slow, get them thinking logically, hopefully on voir dire. You've got plenty of logical thinkers already on your jury, and really get things back to logic and numbers and data. And you're telling them there's a bias without maybe calling it a bias, because people don't always, if they haven't studied behavioral economics, they may not know what that is. So that would be my advice for, just calling out the bias. You may think that we've seen this a lot. This is terrible. We keep seeing it on TV. However, this is very rare. It's isolated. This is what happened. I mean, that kind of thing. It's kind of calling out the bias without calling it a bias. So anyway, I put my information, my email, my website. I'm on LinkedIn all the time, as Jeff knows, so you could DM me there. And if anyone wants a copy of the PowerPoint, I'm happy to provide that. So just contact me, and I'll answer any other questions, unless we shut
Shari,
off.
this was just terrific. Thank you so much. So jam-packed with helpful information for lawyers, negotiators, mediators, not only in litigation contexts, but just in our everyday lives. We can use all of this information so well. I want to remind everybody that you've urged people to contribute to the New York Common Pantry. That's www.nycommonpantry.org. If people are in a position to do that, we appreciate it very much. If you're comfortable letting Natalie know of your contribution, we add it to our running total. We're at $144,000 since we began these Will Work for Food webinars. Let's go, team. Let's hit $150,000 this week. At the peak, we had over 140 people here, Shari, which was one of our largest crowds ever, and well worth it. Thank you so much. And Jean, Natalie, thank you as well. And with that, we are complete.